Hello and welcome to this, our fifth seminar in Davis Blank Furness's series, Commercial Lease Termination and Renewals under the Landlord and Tenant Act 1954. The series is designed for surveyors, property agents, in-house lawyers and landlords and tenants themselves to assist them to navigate the often complex world of commercial landlord and tenant matters. My name is Sean Hackett and I'm a partner and the head of the Davis Blank Furness Solicitors Property Litigation Department. Over the past four seminars, we have built a comprehensive foundation. We began by exploring the statutory protection afforded to business tenants under the Landlord and Tenant Act 94, which I'll continue to refer to as the Act, and the contracting out process. We then examined the mechanisms for terminating the protected tenancies, including the crucial Section 25 notice, Section 26 request, and Section 27 notices. In our third and fourth seminars, we delved into opposed lease renewals, examining both the fault-based grounds and the non-fault grounds under Section 31 of the Act. Today, we're taking a very different direction. We're assuming that the landlord is not opposing the grant of a new tenancy. Instead, we're exploring unopposed lease renewals, which in practice represents the vast majority of lease renewal situations. And understanding unopposed renewals is absolutely critical for both landlords and tenants, because this is where the most lease renewals actually happen. And for landlords, knowing how the court would determine terms gives you the framework for successful negotiation and helps you understand what you can reasonably expect to achieve. And for tenants, understanding these principles helps you assess whether the landlord's proposed terms are reasonable, and it gives you the confidence to push back where appropriate. And of course, for advisors such as surveyors and accountants, grasping these nuances means that you can provide invaluable guidance to your clients where they're negotiating the lease renewal terms. And the principles that we discussed today form the bedrock for virtually every commercial lease renewal negotiation. So let's get started. Today we're looking at the situation where the landlord does not oppose the grant of a new tenancy. When a landlord does not oppose renewal, the focus shifts entirely to the terms of the new lease. And here's where it begins to get interesting, because whilst the parties are free to agree whatever terms they wish, if they cannot reach agreement, the court has the power to step in and determine those terms. The vast majority of lease renewals are concluded by negotiations between the parties without any court involvement, but those negotiations can take place in the shadow of what the court would decide if the matter went to trial. And understanding the court's approach is therefore essential for effective negotiations. We'll be examining three key areas today. First, the general principles that govern how lease terms are determined on renewal, particularly the leading case of O'May versus City of London Real Property Company Limited from 1983. Second, how the court determines the rent payable under the new lease pursuant to Section 34 of the Act, including the various factors that must be considered and, crucially, the matters that must be disregarded. And third, how the court determines all the other terms of the lease pursuant to Section 35 of the Act, including the circumstances in which terms can be changed from the existing lease. Let's start by establishing the legal framework that governs unopposed lease renewals. When a landlord does not oppose the grant of a new tenancy, and the tenant has applied to the court under Section 24, subsection 1 of the Act for a new lease, the court must order the grant of a new tenancy pursuant to Section 29, subsection 1 of the Act. The terms of that new tenancy are then determined in accordance with Sections 33 to 35 of the Act. Section 33 deals with the duration of the new tenancy. It provides that the new lease shall be for such term not exceeding 15 years as the court considers reasonable in all the circumstances. The court will have regard to the length of the current tenancy and consider what both parties are seeking. Section 34 deals with the rent payable under the new tenancy, and this is typically the most contentious issue in unopposed lease renewals. The rent must be the amount that the holding might reasonably expect it to be let for in the open market by a willing lessor subject to certain important disregards, which we'll examine in detail shortly. And then section 35, it deals with all other terms of the tenancy: repairing obligations, service charge, user clauses, alienation provisions, and so forth. The court has a wide discretion to determine these terms, having regard to the terms of the current tenancy and all relevant circumstances. I suppose it's worth emphasising that these sections don't operate in isolation. The rent under section 34 must be determined having regard to the other terms of the tenancy. So if the court decides under section 35 that the tenant should bear greater repairing obligations than under the current lease, that might affect the rent determination under section 34. The interplay between these sections requires careful consideration. Now here's the crucial point. Most lease renewals never reach court. The parties negotiate and reach agreement, often with the assistance of their respective surveyors and solicitors. But those negotiations don't take place in a vacuum. They take place in the shadow of what the court would decide if the matter went to trial. If a landlord knows the court would likely set the rent at £50,000 per annum, there's little point in insisting on £75,000 in negotiations, and the tenant will simply let the matter go to court. And similarly, if the tenant knows the court would likely set the rent at £50,000, there is little point offering £35,000. The landlord will simply let the matter go to court as well. So understanding the court's approach therefore shapes every aspect of lease renewal negotiations. It informs both parties' opening positions, their realistic expectations, and their willingness to compromise on particular terms. And this is why, even though most cases settle, we need to understand in detail how the court would approach these determinations. That knowledge is power when it comes to negotiating the lease terms. Now let's turn to section 34 of the Act, which governs how the rent is determined. Section 34, subsection 1 provides that the rent payable under a new lease shall be that at which, having regard to the terms of the tenancy, other than those relating to rent, the holding might reasonably be expected to be let in the open market by a willing lessor. The section then requires the court to disregard 4 specific matters when determining that open market rent, and these disregards are absolutely critical to how section 34 operates, and we'll examine each in detail. The purpose of section 34 is to strike a balance. The landlord is entitled to receive the open market rent for their property. They shouldn't be forced to accept less simply because the tenant happens to be in occupation. But equally, the tenant shouldn't have to pay more than the open market rent simply because they're the sitting tenant and want to remain in occupation. The Act achieves this balance by directing the court to determine what a hypothetical willing landlord and a hypothetical willing tenant would agree as the rent in the open market for premises of this type with these lease terms. This brings us to a fundamental point about how section 34 operates. The rent determination involves a degree of artificiality. We're looking at a hypothetical transaction between hypothetical parties. We're not asking what would this landlord and this tenant agree. We're asking what would hypothetical parties in the open market agree for premises like these on terms like these. The hypothetical landlord is willing to let, but it's not desperate to do so, and they want to achieve the best rent reasonably obtainable, but they're not holding out for an unrealistic figure. The hypothetical tenant is willing to take a lease, but is not desperate to do so, and they want to secure premises at the best rent reasonably available, but they're not willing to overpay. Crucially, and this is where the artificiality comes in, the hypothetical tenant is assumed not to be in occupation already. This follows from the first disregard under section 34, subsection 1, which requires the court to disregard any effect on rent of the fact that the tenant or their predecessors have been in occupation. The consequence is that the rent is assessed as if the premises were being let in the open market with vacant possession, even though in reality the tenant is already in occupation and it is fitted out. Section 34 subsection 1 requires the court to disregard 4 specific matters when determining the rent, and we look at each in turn. These disregards are central to how the section operates, so let's examine each in turn. The first disregard is occupation by the tenant. The first disregard is any effect on rent of the fact that the tenant has or his predecessor title have been an occupation of the holding. This disregard has several important consequences. First, it means that the tenant cannot be required to pay an inflated rent simply because they're the sitting tenant. In the real world, sitting tenants are sometimes prepared to pay a premium to remain in occupation to preserve their established business location and goodwill. Section 34 prevents landlords from extracting such a premium by requiring the court to assess the rent as if the tenant were not already there. Second, it means that tenants cannot benefit from a discount simply because they're the sitting tenant. In some circumstances, sitting tenants in the open market might expect to pay less, perhaps because the landlord values continuity and wants to avoid void periods. Section 34 prevents tenants from claiming such a discount. Third, and this is particularly significant, means that the rent is assessed on the assumption that the premises are available with vacant possession. The hypothetical tenant is assumed not to be in occupation already. The second disregard is any effect on the rent of the fact that the tenant has or his predecessors in title have been in occupation of the holding insofar as it appears that the goodwill of the business carried on by the occupation has been attached to the holding. Now, this disregard protects the tenant from having to pay for goodwill that they have built up in the premises. Now, goodwill is the reputation, the customer base, and the business connections that a tenant has developed during their occupation. And in many business locations, it is crucial. A shop in a prime high street location may have built up a substantial goodwill over years of trading from those premises. And without this disregard, a landlord could argue that the premises are more valuable because of the successful business operation from them and therefore command a higher rent. Section 34 prevents this. The tenant cannot be required to pay for goodwill that they themselves have created. However, the disregard only applies to the goodwill attached to the holding by the occupier. If the premises have inherent locational advantages, proximity to transport links, high footfall, or prestigious address, that's not goodwill attached to the occupier. That's part of the inherent value of the premises, and it can be reflected in the rent. The third disregard is tenant improvements. The third disregard is any effect on rent of any improvement carried out by a person who at the time it was carried out was the tenant, but only if it was carried out otherwise than pursuant to an obligation on his immediate landlord. Now, this disregard means that improvements made by the tenant during the current tenancy, provided they were not required by the lease, must be disregarded when assessing the rent. Now, the policy behind this is clear. Tenants should not be discouraged from improving premises by the fear that those improvements will be reflected in a higher rent on renewal. If a tenant voluntarily installs better fixtures, improved facilities, or enhanced infrastructure, the landlord cannot demand a higher rent on renewal to reflect that added value. However, there are important limitations. First, the improvement must have been carried out during the current tenancy. Improvements carried out before the current tenancy began can be reflected in the rent. Second, the improvement must not have been carried out pursuant to an obligation to the landlord. If the lease required the tenant to carry out the improvement, it's not disregarded. And third, there's a temporal limitation. Improvements carried out more than 21 years before the application for renewal can be taken into account provided certain conditions are met. These limitations require careful analysis of the history of the tenancy and any improvements made during it. And the fourth disregard relates to licensed premises. It is a disregard applying only to licensed premises holding a license to sell alcohol, and it requires the court to disregard any addition to the rent attributed to the licence itself. And this disregard is less relevant to most commercial property disputes and primarily affects the hospitality sector, so I won't dwell on that today. So how does Section 34 work in practice? Well, the court must undertake a valuation exercise to determine the open market rent, applying the disregards that we have just discussed. This valuation exercise typically relies heavily on expert evidence from surveyors and valuers instructed by both parties. Each party will instruct their own expert, who will prepare a report setting out their opinion on the appropriate rent. Now, those experts' reports will typically include an analysis of the subject premises, size, location, condition, facilities, access, and so forth. Identification of comparable properties, for example, other lettings in the same area or similar areas that provide evidence of market rent levels, and adjustments to those comparables to reflect the differences between them and the subject premises. Considerations of market conditions at the relevant date. Is the market buoyant or is it depressed? Is there high demand or is there oversupply? Applications of Section 34 disregards, for example, removing any elements that should be disregarded. Ultimately, it'll include a conclusion on the appropriate rent. The experts' reports are then exchanged, and typically the experts will meet to try and narrow the issues between them, and in many cases the experts can agree the rent or at least narrow the range significantly. If they cannot agree, the court will hear their evidence and make its own determination. It's important to remember that experts are experts of the court. They're not hired guns seeking to get the best result for either party. Their duty is to the court. The most critical element in any Section 34 valuation is comparable evidence. Comparables are other lettings of similar properties in the same or similar locations that provide evidence of what the market rent is. Good comparables are gold dust in rent disputes. If you can point to 3 recent lettings of similar properties in the same street at £40 per square foot, that's powerful evidence that the open market rent for your premises is around £40 per square feet, subject to any necessary adjustments. However, perfect comparables are rare. Properties differ in size, location, and condition and configuration. Leases differ in their terms, their length, break clauses, repairing obligations, and so forth. The valuer's skill lies in taking imperfect comparables and making appropriate adjustments to reach a reliable conclusion. And courts place great weight on comparable evidence, particularly recent lettings on similar terms. In the absence of good comparables, valuations become more difficult and more subjective. Okay, let's now turn to Section 35 of the Act, which governs how the court determines all the other terms of the lease. That's everything except duration and rent. Section 35 subsection 1 provides that the court shall have regard to the other terms of the current tenancy and to all relevant circumstances. And that's a broad and deliberately elastic formulation. The court has a wide discretion, but that discretion is not unfettered. It's guided by important principles established in case law, and the leading case is O'May versus City of London Rail Property Company Limited, decided by the House of Lords in 1983. This case established the fundamental principles that govern how Section 35 operates, and those principles continue to guide courts to this day. So let's look at the case of O'May versus City of London Rail Property Company Limited, decided, as I say, by the House of Lords in 1983. The case established the fundamental principles that govern how Section 35 operates, and those principles continue, as I say, as of today. So let me set out those key principles of O'May. Principle 1, you start with the current lease. The court must begin by considering the terms of the current tenancy. The current lease represents the bargain struck by the parties when it was originally negotiated, or the terms imposed by a court on a previous renewal. And the current lease is the starting point, not just one factor among many. It has primacy. Principle 2 is the burden of proof. The burden of persuading the court to change the terms of the current tenancy rests on the party proposing the change. If a landlord wants to add a service charge provision that wasn't in the original lease, the landlord must justify that change. If a tenant wants to add a break clause, the tenant must justify that change. The party seeking to maintain the status quo doesn't need to justify anything. They can simply point to the existing terms and say, these worked before, they should continue. And the third principle is fair and reasonableness. Any proposed change must be fair and reasonable in all the circumstances, and that is an objective test. The court isn't asking whether the changes would be advantageous to the party proposing it. Of course it would, otherwise they wouldn't be proposing it. The question is whether it's fair and reasonable as between the landlord and the tenant. And the fourth principle is to consider the tenant's position. When assessing whether a change is fair and reasonable, the court should take into account the comparatively weak negotiation position that the tenant is in. This reflects the protective purpose of the Act. The tenant is to some extent at the landlord's mercy. They need the premises for their business and they've built up goodwill there, and moving out would be disruptive and expensive. And the court should not allow the landlord to exploit that weakness to force through changes that the tenant would never have agreed to in the open market negotiations. And principle 5, this is the wide discretion. And it's subject to the above principles that the court has a wide discretion. Lord Wilberforce in O'May described this discretion as elastic, something between an obligation to reproduce the existing terms exactly and an unfettered right to substitute different terms. And the court can change terms where there's good reason to do so, but it starts from a presumption in favour of maintaining continuity. So I suppose the big question is, when will the court allow terms to be changed on renewal? Let me give you some practical examples drawn from case law. Modernisation to reflect legal changes. The court will generally allow terms to be updated to reflect changes in the law since the original lease was granted. For example, if new legislation has been introduced imposing obligations on landlords or tenants, such as energy efficiency requirements or fire safety obligations or data protection duties, it may be fair and reasonable to update the lease to reflect those new legal requirements. The key is that the change isn't fundamentally altering the bargain between the parties. It's simply ensuring the lease reflects the current legal landscape. Another one is correcting obvious anomalies. So if the existing lease contains an obvious anomaly, an error or an omission, the court may correct it on renewal. For example, if the existing lease inadvertently failed to include an insurance clause or included a rent review mechanism that doesn't work properly, the court may correct these defects. The third one is updating the administrative provisions. The court will generally allow updating of administrative provisions that don't fundamentally affect the commercial bargain that was struck. For example, updating payment methods to allow for electronic transfers rather than checks, or updating notice provisions to allow for an email as well as by post. And also market practice with limited relevance. Now this is an important point. The court will not change terms simply to reflect current market practice. The fact that most leases granted today include particular provisions of break clauses, caps on service charge, green leases provisions, does not mean that those provisions should be imposed on a renewal lease where they weren't in the original lease. As the House of Lords in O'May stated, there's no obligation to make the new terms conform with market practice if to do so would be unfair to either party. Market practice can be relevant evidence of what is generally considered fair and reasonable, but it's not determinative. Conversely, when will the court refuse to allow changes? Shifting fundamental risks is another example. As we saw in O'May, the court will not allow changes that shift fundamental risks from one party to the other. If the existing lease places the risk of certain costs or events on the landlord, the court will not generally allow that risk to be shifted to the tenant on renewal, even with a corresponding adjustment to rent. And opportunistic changes, the court will not allow that. If a party seeks to use the renewal process to extract concessions they could not have negotiated in the open market, the court won't tolerate it. For example, a landlord cannot use renewal as an opportunity to impose onerous restrictions on the tenant's ability to assign or sublet or remove a break clause that the tenant had negotiated in the original lease. And uncompensated burdens. The court will not impose additional burdens on one party unless those burdens are appropriately compensated. For example, if a landlord proposes to impose an additional repairing obligation on the tenant, there should be a corresponding reduction in rent under Section 34 to reflect those increased obligations. Let me now draw together some strategic considerations for landlords dealing with unopposed lease renewals. The first one is early engagement. Starting the renewal process early. Don't wait until the last minute. Early engagement allows time for negotiations, getting experts' reports if necessary, and court proceedings. Another one is know your market. Ensure you have up-to-date market intelligence. What are the comparable properties letting for? What terms are standard in the market? This knowledge is essential for the credible rent negotiations. And then prioritize your objectives. Identify what's really important to you. Is it the rent? Is it the length of term? Is it particular lease terms? You're unlikely to win on every point, so focus your efforts on what matters most. And don't be greedy. Resist the temptation to use renewal as an opportunity to impose multiple changes to the lease terms. The O'May principles mean that the court won't allow wholesale rewriting of the lease. Focus on changes that you can justify as being fair and reasonable. And be realistic about rent. Obtain professional valuation advice early. If your surveyor tells you that your market rent is £50,000, there's no point in insisting on 70,000. You just waste time and money in the litigation, which you're ultimately going to lose. And document everything. If you're proposing changes to lease terms, document your justification. Why is this change fair and reasonable? How does it benefit both parties? What's changed since the original lease was granted into that justifies this change? For tenants, here are some strategic considerations you might think of. Challenge unreasonable proposals. Don't simply accept whatever the landlord proposes. If the landlord is seeking to change the terms from the existing lease, they bear the burden of justifying those changes. Require them to explain why each proposed change is fair and reasonable. Obtain expert advice. Commission your own survey to provide an independent valuation of the market rent. This gives you objective evidence to support your position and helps you assess whether the landlord's proposals are realistic. And consider your own changes. Don't think of renewal as simply defending against the landlord's proposals. Consider whether there are changes you want to propose, perhaps a break clause, different alienation provisions, or updated user provisions. You have the same right to propose changes as the landlord, subject to the same O'May tests. And negotiate holistically. Don't negotiate rent in isolation from other terms. Now, the rent under Section 34 is determined having regard to all other terms. So if you're accepting more onerous repairing obligations, that should be reflected in a lower rent. And know your walkaway point. Identify your walkaway point before negotiations begin. At what rent or on what terms would you prefer to relocate rather than renew? Knowing this helps you negotiate with confidence. And use time strategically. The statutory timescales work in your favour as a tenant. You can't be forced out until a court determines the terms of a new lease or refuses to grant one. Use this time to negotiate effectively, but don't abuse it. Courts take a dim view of tenants who drag out the proceedings unreasonably. We've covered a great deal of ground today, so let me crystallise the key points that you need to take away. First, unopposed lease renewals represent the vast majority of lease renewal situations. Understanding how they work is essential for anybody involved in commercial property. Second, the court determines renewal terms under Sections 33 to Section 35 of the Act. Section 34 deals with rent, Section 35 deals with other terms, and Section 33 deals with duration. Third, the rent under Section 34 is the open market rent assessed for a hypothetical letting between a willing lessor and a willing tenant, with 4 specific disregards: occupation by the tenant, goodwill attached to the holding, tenant improvements, and for licensed premises, the license itself. Fourth, determining other terms under Section 35 is governed by the O'May principles. The current lease is the starting point. The party proposing the change bears the burden of proving that they're fair and reasonable, and the court will not allow changes that shift fundamental risks or exploit the tenant's weak negotiating position. Fifth, most leases renewals are concluded by negotiations rather than court determination, but those negotiations take place in the shadow of what the court would decide, and understanding the legal framework is essential for effective negotiations. And sixth, expert valuation evidence is crucial. Both parties should obtain independent surveyors' reports early in the process. And finally, be realistic, be strategic, and focus on what really matters. Don't waste time and costs fighting over every minor point. We've now completed 5 of our 6 seminars in this series. In our final seminar scheduled for Monday, the 8th of December, we'll be examining some specialist topics that frequently arise in lease renewals, but that we haven't considered in detail yet. We'll be looking at interim rent applications under Section 24A of the Act, when a tenancy is holding over after the contractual term has expired. Should the tenant continue to pay the old rent, or should they pay an interim rent reflecting the current market rent levels? How is interim rent determined, and how does it differ from the rent under the new lease? We'll also examine guarantee provisions in renewal leases. If the original lease contained a guarantee from a parent company or director, should the new lease contain equivalent guarantee provisions? What happens if the original guarantor is no longer appropriate or available? And we'll look at alterations and reinstatement provisions in the renewal lease. What happens if the alterations were undertaken during the current tenancy, which is about to end? And of course, should you require assistance with drafting notices, lease renewals, or disputes under the Act, our property litigation team is equipped to support your commercial objectives. And please contact us for tailored advice. All that remains for me is to thank you for joining us, and I hope you can join us on our next seminar. A recording of this session and a copy of the slides will be uploaded to our website. We look forward to seeing you for Seminar 6, Interim Rent Guarantees, Alterations in Renewal Leases, on Monday, the 8th of December 2025.